Q&A, we may have some interesting questions coming up. To round off, we have Ratan from India.
Good morning, everyone. I'll be speaking on enforcement of court judgment, foreign judgment, and enforcement of foreign awards in India. First of all, a few words about foreign judgments. We have a civil procedure code in India, Code of Civil Procedure, we call it. There are three sections, three provisions in Civil Procedure Code, which takes care of, deals with the enforcement of foreign judgments. We have Section 13, Section 14, and Section 44A. These are the only three provisions which deals with enforcement of foreign judgment. What are the preconditions? First precondition is we should have reciprocity with the particular country from which this judgment is coming. And there has to be a gazette notification by the government of India. And not only gazette notification about the country, but gazette notification also about the court from which the superior court, because the Section 34 and Section 33, if we read together, it tells us that it should be from a superior court. So judgment coming from a country should be a recognized, reciprocated country. And secondly, the superior court should also be notified. That is one. Secondly, if we look at Section 13 of the Civil Procedure Code, it tells us what are the judgments which are really conclusive in India. Because in a judgment, for enforcement of a judgment, it is a precondition that it is conclusive from Indian perspective. So what we really look at, if we look at Section 13, we look at whether this judgment is rendered by a court of competent jurisdiction, whether the defendant in that particular suit was really party to that proceeding, whether this person had submitted to the jurisdiction of that court, whether principles of natural justice or due process were really followed or not. These are typical preconditions in order to be a conclusive judgment which can really be enforced in India under Section 34. Second important aspect is when we talk about judgment coming from different jurisdiction, what is the procedure? What is the procedure which we talk about? If a particular judgment is not coming from a territory or a jurisdiction with which India has got any reciprocal arrangement, and we have this notification, in that case, such a judgment will be taken as a fact, and then one will have to really go and institute an action, and we will have to really go ahead with that. And in India, we do not have in that restrictions which so Ramsey was talking about a summary procedure. So we will have to have a full-length draft, full-length action. Obviously, it will be a relevant fact which court will take into consideration. Now, when we talk about judgment coming from a country with which India has got reciprocal arrangement, how do you go to Indian courts? For Indian courts, you have to take out an execution proceeding, and because once it is from that particular country, it can be executed as a degree of the Indian court. So you go to an executing court, file a proceeding, and you can go to any court where the asset is lying, because ultimately you are going to execute your degree, until unless we are talking about it is a judgment against a person, where you want some specific performance. You have a degree for a specific performance, you want this to be really specifically enforced, or you have a judgment against somebody which is really in the nature of or you want somebody to really comply with certain requirements. So for that, you can go to any of the courts. Otherwise, you go to a court where subject matter is situated, or you go to the court where this person is having assets. There is provision for also transfer of the execution proceedings from one court to another. So if you have gone to one court and if you find that the asset which was lying there has been transferred to some other jurisdiction, you can get it transferred there. Execution proceedings, sometimes what happens to go against a particular person, you are aware about certain assets, but you are not really aware about other assets, whether this person is having assets or not, other assets or not. There is one provision in our civil procedure code where court can direct the party to disclose on affidavit what other assets he is having. And if the person is filing it on affidavit, obviously court will be conscious of the fact that this particular statement is coming on affidavit. And if a person is not filing affidavit, in that case, the person can be sent to civil imprisonment. Obviously, for civil imprisonment, one has to pay some cost, because it is civil imprisonment, it's not an imprisonment under criminal procedure, but in the law. That is typical about the execution procedure. If you want to know how much time does it take, the procedures for execution in India, if you see that code, it is the lengthiest provision. You have multiple sections and orders which talks about this execution procedure. So one has to be careful with the execution procedure. You should be very you should have all the strategy in place, which court you are going to, what are the assets there. Because with the execution proceeding, you have to mention the list of assets, what are the assets against which you want to go ahead and want court's protection. So, and how it happens, you go to a particular court, file your execution application, list out the assets, you request the court, these are the assets, kindly be attached, these are the assets, kindly be sold, and court will help you. This is simple, but you will have to be very strategically correct in going to the right court and knowing about all assets. There is something these days lots of people do. If you are not aware of exact assets, location of assets, you can hire investigative agencies and they can get you the assets and details of the assets. So this is typical about the enforcement of foreign judgments. Now, when we talk about enforcement of foreign awards, India is signatory to New York Convention, one of the oldest signatories. India is signatory to Geneva Convention. So, and we had earlier laws when we signed the New York Convention and Geneva Convention protocols. We had all the legislations in place. But in 1996, we had a Arbitration and Conciliation Act 1996, which consolidates everything under one act. We basically, whenever we talk about arbitration in India, there are questions in the mind of people because there have been certain judgments in the past which really gave rise to a lot of confusions, including when this is all white, which was the judgment on the grounds on which awards can be set aside in India. Then you had certain other judgments like Bhatia International and after a couple of other judgments mentioned global. These two judgments, Bhatia International, in fact, Bhatia International have gone to the extent of saying that the Part 1 of Arbitration and Conciliation Act, which deals with domestic proceedings and domestic awards, those provisions can even apply to foreign seated arbitration, and Indian courts can even interfere in those proceedings and apply those provisions which are otherwise meant for the domestic arbitration, which are under Part 1. I must say there are two developments, recent developments. One, that the Arbitration and Conciliation Act of 1996 is undergoing substantial change now. It has been approved by the cabinet. It has taken care of all those gaps and all those lacunas which we were encountering because of certain judgments of Supreme Court. Those have been taken care of because, and then there is another interesting development which we have seen, that all those judgments which were really taken as troubling judgments by us in India as well as by the international arbitration community, those have been overruled by Supreme Court of India, the highest court in the country. So I would say that nobody is now, at least on those counts, whether it's Bhatia International and so on and so forth. Now, when we talk about enforcement of foreign judgments, what we need to see basically is we have section 44, which talks about what is foreign award. And then we have section 48, which says when a particular foreign award will not be enforced. Again, it will have those typical preconditions, and which we see in Article 5 of the New York Convention, which is basically the New York Convention and Geneva Conventions are, and Geneva Protocol, are basically scheduled to the Arbitration and Conciliation Act. So Schedule 1 is New York Convention, Schedule 2 is Protocol, and Schedule 3 is Geneva Convention. So all are scheduled to our Arbitration and Conciliation Act, or Part 2, which deals with foreign award and enforcement of foreign awards. When we talk about preconditions are, because we all know Article 5, so what we basically say is that it has been given on merit, it has been given by a court of competent jurisdiction, due process has been followed. So I did not really take too much of time on that particular aspect. Yes, what is something which everybody wants to know about India is, what happens if an award has been rendered by a foreign court? Can such an award be set aside by an Indian court? That was one very good, that was one issue. Because Bhatia International had said we can set aside the award. Because they said the section 2 of Arbitration Conciliation Act does not exclude foreign awards, and since in the part 1, which deals with setting aside of award, they said why cannot it be a foreign award? This judgment has been overruled by Balco judgment, Bharat Aluminium judgment, Bharat Aluminium versus SCL Aluminium, 2012. Yes, this judgment has one particular issue which some of us are concerned with. That is, it has given prospective effect to this particular judgment, because concerns of the judges were that this Bhatia was there for a long time, and courts have followed that judgment. Therefore, we need not apply this judgment with retrospective effect with regard to the agreements which were executed prior to Balco. So one thing is, whenever you have an arbitration agreement which was agreed between the parties prior to Balco, the law prior to Bhatia will apply, law prior to Balco will apply, else we go ahead with that. Another issue was, what should be the standard, what should be the threshold for, on the issue of public policy, because that was another issue, because we had a couple of judgments in India, like Venture Global, and which said the public policy for the, which we understand for the domestic awards should be applied even with respect to the foreign awards. That necessarily means that even on the ground of patent illegality, because in India there is a judgment called ONGC South White. ONGC South White says award can be set aside. It talks about domestic award. It said award can be set aside even if we find some patent illegality, if it is against the substantive provisions of law under Section 28 of Arbitration and Conciliation Act. So it has really enlarged the scope for setting aside the award. This issue has been taken care of by Supreme Court in the latest judgment in Sri Lanka. Now Supreme Court says, with regard to the foreign awards, Indian courts will not apply when we talk about enforcement or otherwise. It will not apply those ONGC Southwide principles, patent illegality, and all. For that, it has to be those international standards when we talk about international public policy. So those concerns have been taken care of by the this latest judgments by Supreme Court, and we have our new act coming in place. Maybe in a couple of months we will have a new act also. So I think with this, I will stop. Thank you very much.